back to my live presentation. I'm Jen Tozser, and I'd like to thank Christianne Murphy for coming here today. She's a lawyer with Underwood Gilholme, and what's really unique about Christianne is that she actually has wills and estates as her primary business. Oftentimes in business, your person who does your wills and estates lawyer happens to be, your corporate lawyer, your friend, potentially your will kit. And I thought it was really timely to just have someone who's an expert in wills and estates to give us a quick presentation about what's going on. I have Dustin here. You can't see him. He's going to be actually moving the slides forward for us. And then David's also going to show me any questions that get asked in the chat. The questions are probably not visible. If they don't come through during the presentation or we don't have a chance to answer them, we'll get them answered for you afterwards. And I will keep admitting people as they pop in, which is fine. So let's get started. Dustin, can you give us the next page, please? So this is the topic of what we're going to cover. It's pretty comprehensive. And as I said, if there's anything else we need to talk about, we'll go through that at the end. Next. Okay. So I just want to start here with why estate planning matters. And I'm going to just toss this out to Christianne because just as a basic thing, Christianne, how many people actually have a will?
Yeah, it's a really timely question because I recently saw an article about less than half of Canadians have an up-to-date will. So even if they have a will, it doesn't accurately reflect their wishes, or they just have no will in place at all. So yeah, let's say roughly half of people have an estate plan.
So basically that means half of you who are listening haven't got a will. So that's the other reason we're doing this. And Christianne, what happens if you pass and you don't have a will? Just generally, what's the process? What happens?
Right. So if you pass and you don't have a will, then your family or friends, somebody will have to basically step forward to get a grant of administration from the court, and that will enable them to deal with your assets. But in terms of how to distribute your assets, they're then bound to what the legislation says. And there are intestacy rules written out in the legislation that determine who gets what. So sometimes that's okay, but more often than not, it's not okay. There are a lot of misconceptions out there about where assets go when you pass away. So if you die without a will, your family or friends have the headache of obtaining the grant of administration from the court. They're bound by following the intestacy rules, and you really miss the opportunity to make sure that your wishes are carried out the way you want them carried out. Certain individuals might not be properly protected. There can be all kinds of extra arguments that tear people apart, which is probably not the legacy that you were hoping to leave. So yeah, basically, it causes a big mess.
Okay, so it causes a mess. So we're going to talk about potentially why people don't do a will, but let's just get down to some of the numbers here. And I know that a typical will costs on average about $2,500 to write. I think for clients here, you might get to write your will for a slightly less amount. But if you were going to talk about the costs of doing this, of advancing an estate when you didn't have a will, do you think there would be more or less than that $2,500?
I think it would be more for sure, because you miss out on the opportunities for planning. If you want to avoid probate, there are strategies we can put in place to avoid probate. I will just say that in Alberta, we have the best, I guess Alberta is the best place to die because we have the lowest estate fees. So the probate fees at court max out at $525, whereas in places like Ontario and BC, you get charged a percentage of the value of the estate. And Alberta actually has the new surrogate digital service. So I've had some grants of probate come back in a matter of weeks instead of it can take a year or more in some of the other provinces. So it's avoiding probate is an important consideration, but it's not always as big a deal as it is in other provinces if you're chatting with friends or family in other provinces. But so if we do streamline things so that the estate doesn't have to go through probate, then obviously it's much cheaper than if you die without a will where they have to go and get a grant of administration from the court. But that doesn't even begin to take into account the legal fees if somebody disagrees in a situation where there was no will. So, yeah, I mean,
So write a will is your summation.
yeah, yeah.
Okay. Dustin, can you move on to the next slide, please? Okay, great. So this is what a will is. Will, I mean, we all know what a will is. We've all seen TV. It's basically a document that tells you what you want to do. I want to talk about the executor for a minute. And when I say I'm going to talk about the executor, I'm going to say, Christianne, what's important when you're picking an executor? What should you look for?
Yeah, I think that's
What
something that stumbles a lot of people. Like they get stuck thinking about who to name as the executor, and it's really a stumbling block. So I think if you're stuck on determining who should be the executor, some of the things to look for are they someone you trust? First and foremost, you need to trust them because they're going to be managing your assets. But you also want to think about, do they live locally? Because if you live out of province, then the court has the right to ask that person to post a bond equal to the value of the estate in order to actually administer your estate. Now, there are ways around that, but it's another consideration. You want to think about whether they have the financial acumen to be able to deal with numbers and manage the estate. You want to think about their age. For example, I think a lot of people default to naming their spouse, which is great, but they're probably around the same age as you. So you want to think about backups who might be the generation below you or just a bit younger. Um, their willingness and time, like availability to actually do the job, is a really important factor. Yeah, I can go on. There are multiple factors, but I want to make sure we get to all your questions. So
I actually do have a question. This is our first call-in question. Um,
okay,
so let's just assume that I name someone as an executor. And it's a two-part. This is my question, then I'm going to have the question from the clients here. The first
okay.
question is, I want to talk about a note of province. So just to recap what you said. So let's say I've got a client and they've been named executor for somebody in a different province, BC. And the person in BC has a house of $2 million and an estate of $1 million. Does that mean that the person in Alberta who has been named executor has to potentially post $3 million in order to do that job?
So that's a really good question because in that situation, it would be the laws in BC that apply because every province has its own specific legislation for estate administration. Alberta operates very differently to BC and Ontario, and actually all of the provinces operate pretty differently to each other. So I could flip the question and say, if it was the other way around and the individual who passed away with $3 million in assets lived in Alberta, but their executor lived in BC, then the court could potentially ask that executor to post a bond for $3 million in order to administer the estate of the deceased Albertan. As I said, there are ways around it and certain ways to try and mitigate the risk of the court asking for that, but it is something to consider for sure.
What would be just a really quick answer? What would be an example of I'm not going to hold you to it, but how do you mitigate that so that doesn't happen? Like
So
what,
I like to put a clause in my will that explicitly says that you don't require the person to post a bond. However,
um,
the court ultimately has the discretion to decide that. So we used to joke that, it's only because everyone outside of Alberta is a thief. So that's why they do it. But really, it's about like making sure that you can collect assets in the jurisdiction. So it's more about jurisdiction and most of the time we are able to get around it, but I know that there have been some situations lately where the court has said no, bond is required. So
Okay, this is great. This is great because the other thing, and I'm going to just mention before I ask this next question, is one of the things I see in all tax planning and estate planning or any type of long-term planning is that things change. So rules change. So I'm glad you brought this up because that's just not something I was aware of because I've never seen it, but that doesn't mean it's not there. So
yeah,
let's take an example. Let's say I keep saying my will, but in the will,
yeah.
someone names an executor, and then the executor, looks and says, "I can't do this. I'm too busy. I'm too far away." I don't have the ability to do this right now because of all these other things. What choices does the person named as executor have if they can't do the job? Can they, how do they relinquish it and can they relinquish it? And who do they relinquish it to?
Yes, great questions. So if it's early on in the process, let's say that the testator, the person who wrote the will, has just passed away and the executor hasn't started acting as the executor yet, then they can sign a renunciation saying that they're not going to act, basically. Um, Unfortunately, if they have started acting and they've taken certain actions which we call intermeddling, then it's much more difficult to get out of the executor role at that point. So you want to make sure that if you are appointed as the executor, you talk to an estate lawyer right away to figure out, is this something that I can actually do? And if you're even appointed as an executor for someone, don't wait until they pass away to figure out. Let them know, if this looks like it's going to be something that you can't do, then it's good for them to name someone who is willing to take on the role. If they've intermeddled, then they need to bring a court application to be removed as the executor. If it's a simple renunciation at the beginning of the process and they've named an alternate in the will, then it goes straight to the alternate in the will. If they haven't named an alternate in the will, then you go to the legislation and there's specific priority that they give to different groups of people to apply to the court to act as the executor.
Okay. And I also wanted to add, just as a, just as a point, is that you can also name a professional, like a corporate executor. And National Bank does, of course, have an office you can name
Exactly. Yeah.
as an
Professional executive.
executor.
Yeah.
And don't you can change this person as well. So, if you don't have, if you name National Bank today and 10 years later you want to name somebody else, you can, right? This can be changed. It's not as if it's a long-term commitment. So,
Totally.
um, that was a comment. Okay, we should probably move on to the next slide. And by the way, I know we're not caught, hitting, every single point on every single slide. It's because I wanted to really focus on the things that are new or the things that we haven't really thought of, we don't regularly think about. So again, if you have any questions, just send them in. And this one I wanted to talk about specifically joint property. And why I wanted to talk about joint property is because this is something that we see more and more happening for different reasons. People buy a house together. Somebody's on the house to help out with a mortgage. You buy your kid a house and then you lay a mortgage against it, even though if there's not real mortgage, or you have a friend, or you're married. And one of the things is that I want Christian, can you talk about some of the things that you have seen that are anticipated or unanticipated with joint property and death and the will? Some scenarios you've seen and things we should be aware of as clients.
Yes. Yeah. Joint property, I think, is a really, really misunderstood one. So, when you own assets jointly with your spouse and one of you passes away, then it passes by right of survivorship to the surviving spouse, which is usually fine. That's usually what you want. However, people often also put their children jointly on the property, which is not a good idea for multiple reasons that I can tell you a bit about that. But I think one of the main reasons why people put their children jointly on the property is because they think then the child will be able to help them manage the property, and having joint houses or joint bank accounts with adult children is it can be really problematic for multiple reasons. So first of all, once you add them jointly, you kind of lose control of a large part of that asset. If you want to sell it, you might need their permission. If they drain the bank account, you might not have any recourse. If their marriage ends and there's a matrimonial property breakdown of that child, then your assets could become exposed um, to matrimonial property claims. If they get into financial difficulties, your assets could be exposed to creditors. If you have your child's name on there and you pass away, there's a rule about survivorship when it's jointly owned with an adult child. So it's presumed that that property is being held in trust by the adult child for your estate. So sometimes what will happen is, let's say, elderly mom has daughter move into the house with her and puts daughter jointly on title to help manage the property. And mom and daughter have an agreement between them that, okay, the plan is that because you've come in and helped me, I will let you, this house will go to you when I pass away. I want survivorship to apply, and you'll get the house as a thank you for living with me and taking care of me all these years. Meanwhile, the son who lives wherever else and is not being as helpful doesn't know that mom has come up with this plan with the daughter, or does know and is greedy and doesn't care. So when mom dies, that house goes to the daughter, but son says, no, that house is actually part of the estate. My sister is just holding it in trust for the estate. And so there's this presumption that she's holding it in trust. And if she doesn't have any evidence to rebut that presumption, then she's out of luck. So it can get really complicated when we put assets in joint names for estate planning purposes, other than if you put it in a joint name with a spouse.
What about it is let's just assume that I'm going to go back to your scenario. Let's say this is happening. We've got, son who lives on the other side of the world. He doesn't really do anything. And, the daughter lives in town and lives with mom, and
Yeah.
mom wants him to have the house and puts her on the title because she puts her on the title. She didn't listen to you and she did it anyway.
Didn't. Ugh.
Oh, so then what would happen? What were some things that you could do to make sure that some child that's not getting the equal amount or is getting a lesser amount is it's your will doesn't get contested in court? What are some things you should do?
Yeah, so I think it's really important to document all of this stuff properly in a proper will. So if I had a client come to me with that fact scenario and mom is still alive and we're doing her will, I would put a clause in there that says, I jointly own this house with my daughter. The legal ownership is joint, the beneficial ownership is joint, and it's my intention that when I pass away, the legal and beneficial ownership of the property passed to my daughter by right of survivorship. And my daughter does not hold this property in trust for my estate. And then I would also get them to sign a deed of gift saying that they're gifting the house to the daughter when they pass away, that it's not being held in trust. Just backing all of these things up with a lot of evidence, basically.
So this is really good because in Alberta, as you say, we don't have these major probate bills, but people in BC and Ontario do. And people in BC and Ontario who are thinking of doing this to avoid probate are probably not changing their will to reflect this new potential, trust situation that the courts have taken. So, again, go basically talk to your lawyer, make sure it's documented properly. And remember, rules change because I don't think that concept of a joint an adult child and a parent having a joint property, that there was a trust relationship has been around for a long time. I think that's relatively new.
Yeah, it's definitely a good point to keep an eye on changes because litigation is constantly going on. Even if the legislation, if there are gray areas that the legislation doesn't cover, there are going to be cases that are figuring out what the law is, and it's constantly changing. So it's a really important thing to keep an eye on. Yeah.
And while we're talking about joint ownership, what about this scenario? This is just another question. So let's say that the parent bought the child a house.
Yeah.
$1 million, I bought you a house. But you know what? I
Nice
don't know
guess.
who's going to, I don't know what's going to happen. So I'm going to put $1 million mortgage on there. But there's really no intent for the child to repay. But when you're doing your will, how do you best make sure that there's not $1 million encumbrance on that child where, the other siblings say, hey, wait, kid number A with the house owes the estate $1 million. Do you just forgive it in the will? Do you say this mortgage is forgiven? How do you do that best? What are
Yeah,
your
so there are a few different ways to structure it, and a lot of it depends on protections that you want to keep in place for the child who you're gifting the house to. If you don't like their girlfriend or boyfriend, then maybe you want to structure it as a loan, so that, if there's a breakdown of that relationship, that asset isn't up for grabs. Um, if you if it's your intention that it's forgiven on death, then think about ways of equalizing that in the estate. Are you planning on buying $1 million houses for your other two children? What type of documentation is going to be required? What should your executor rely on as evidence that these gifts have or haven't been given? And so really just making sure that there's clear legal drafting around those major gifts is really important.
And there's one other thing with it that Christiane and I were talking about a day or so ago that I just like to mention, and I always say when I'm talking to people about their will that you can't get less in death than divorce. And Christiane, do you want to talk about that joint property situation where you know with the husband and wife and the kids that we were talking? Do you remember which one we were
Yeah,
talking
yeah,
about?
yeah,
Yeah.
for sure. That was an interesting one because it was a case where a woman had tried to draft her own will. She had a couple of properties. Each of them was worth, she thought that each of them was worth roughly $800,000. So there's a lot of issues with splitting up your estate the way I'm about to explain, but I'll tell you the one where this went sideways. So she decided to give one property worth $800,000 to her daughter, and she decided to give the other property worth $800,000 to her son. So she passes away. The daughter gets the one property worth $800,000 free and clear. That's her gift. But the property that she was going to leave to the son is actually jointly owned with her husband. And the husband and son don't get along. So either way, she couldn't have gifted that jointly owned property to her son because she owned it jointly with her husband. So his gift is void. The husband is not going to write the son into his will to give him anything. So the son ends up with nothing and the daughter ends up with everything.
Okay, so this is good. Okay, and by the way, just as an aside, I sometimes when we talk about these things, we always talk about all the negative things that happen. So I said, so Christiane, tell me, just when you write a will and it goes smoothly,
Yeah.
what's kind of how long can when you're working with it, how what's your the single best? Now for clients, this isn't going to be every time, but the single best, speediest will you've resolved where there was a house and some assets. How fast was it roughly?
Yeah, so I've had grants of probate come back in less than 2 weeks now with the new surrogate digital service. I think sometimes it's more um, working slowly enough with the grieving family to get all the information I need in order to get the process going. But it's really not nearly as cumbersome and difficult as it used to be to get everything you need in order to get an estate resolved. So it used to be that it would take a year. Now it's taking a few weeks.
That's great. Thank you.
Yeah.
Dustin, can we see the new, so for all of your clients who have this, now we know that this makes a difference. Okay. Beneficiaries. Okay. I talked on this a little bit right now. We're talking about joint ownership. One of the things that we always advise our clients of and what is that be very careful when you're listing beneficiaries on certain assets, such as your RSP or your pension. Make sure it's consistent with what it says in your will. And Christian, again, you're our expert. What
Hmm.
happens when they don't match?
Yeah, so if they don't match, then technically it's the beneficiary designation that was made later in time that governs. But there is some case law out there about a situation where the bank had relied on their own paperwork to release the funds, and it what they didn't ask about the will, so they didn't see that in the will it had been given to the beneficiary designation had been updated to someone else in the will. So they relied on their documents to pay out the funds, and the court basically said, okay, like, it's the testator's duty to make sure that they match up. Although technically it should be the beneficiary designation later in time is the one that governs. So it can be a really big problem if they don't match up. But another big problem that I see with beneficiary designations is if you name inappropriate people to receive the assets, basically. So, what I mean by inappropriate is like if you name minor children to receive those assets directly, then the funds don't flow through your will and into the trusts that you've set up for those minor children. And they can't hold assets until they're adults. So the public trustee holds the assets and then gives it all to them when they turn 18, and they take all their friends to Vegas because they don't know what to do. So I think being really careful with who you name as your direct beneficiaries for RRSPs and TFSAs and life insurance, everything like that is really, really important. If it's a spouse and it's just going to one person, that's probably fine. If it's in any way going to multiple people or beneficiaries who need trusts, like children or people with disabilities or addiction and spending issues, anything like that, then you probably want it to go to your estate so that it can flow through your will and into the trust that we need to set up for
those people. Okay, we're going to move right along. Thank you. Okay, so common trusts and wills. Um, Now
trusts.
yeah. So I'm gonna force Christiane to do this quickly because the thing is that we could probably spend 2 hours talking about all the different types of trusts. What type of trust do you see? Okay, I'm going to talk about me now. Up until they
Okay.
changed the tax rules, I told everybody to get a testamentary trust. And I told everybody to put in testamentary trusts because they have preferential tax rates. Now those are gone. There's no preferential tax rates. As a matter of fact, they're now all taxed at the highest marginal tax rate. So testamentary trusts went from being great to being essentially terrible. But what are the cases where you see people most often using trusts? In what scenarios, even though the taxation has changed, should you really be considering them for your will?
Yeah, so I think it's really important to do a trust for young beneficiaries. So obviously for minors, because they can't legally hold property till they turn 18, but often 18 is too young to give someone a significant amount of money. And I think a lot of people tend to want to give some practice money as well and some parameters around how the money should be used. So when I do trusts for minors or young beneficiaries, I essentially say that the executor or whoever is acting as the trustee of the trust can dip into that trust to pay for things like education and clothing and things that are reasonable and make sense. But they can't just give big lump sums to the children for paying whatever they want to or for buying whatever they want to until they reach whatever age. And I like to give them some practice money. So I stagger the distribution and give them, like 10% at 21, or depending how much money it is. If it's millions, then you probably don't even want a 21-year-old to have that much. But giving them some practice money so that if they screw up the practice money, then hopefully they've learned some lessons. And when they get the next bigger chunk, they will be more responsible with it, and they haven't screwed up, the whole thing yet. And that also helps protect them from, if they move in with their first girlfriend or boyfriend, that money is protected in that trust. They're not going to receive it right away and lose half of it to that first partner because they didn't know how to protect it. So yeah, I think children's trusts for young beneficiaries are probably the most common one I do. And I always, always, always recommend it because I did have a client where they didn't put a trust in, and there was about $6 million that ended up going to this 18-year-old who, like, he knew that it was coming, so he didn't care and he didn't try. And I think, sometimes the wrong person receiving a large amount of money can actually ruin their life instead of what the testator intended it to do, to help them set them up. So yeah, I think trusts for young people is the most important one in my books.
Okay. And then now this is a question for you, but it's actually me that's going to answer it because it's about people who are still alive. So the question here is it better to gift your assets when you're alive or when you've passed? And what I would tell you, as a client is, we call it the warm handshake versus the cold handshake. Once you're retired, you can give some money, but if you give all of your money and you keep living, then you're in that same relationship that Christiane also already described, where they told you they were going to look after you, and then they told you you don't need it. So ideally, yes, on your, deathbed, knowing that you're going to die for sure, you distribute everything. But there are also other restrictions with the powers of attorney, which may have been enacted at that time. And I've run into this, and Christiane, actually, we're skipping all over in her presentation. You can talk about it more. But because I think powers of attorney is next, but if you are a power of attorney and you come to the well to get money out of the account, it's actually only allowed to be used for the individual who granted it. So if, mom, here it is, mom has gotten a power of attorney, and during power of attorney and has a stroke and gives it to her daughter, and her daughter says, okay, mom's got $5 million. I'm going to, take this all in my name now and avoid probate tax. the investment advisor slash the bank or wherever you're dealing with your money should say, no, you can't have that money. It's only for your mother and it can only be used as your mother would have used it. Christiane, do you want to talk about EPA some more than
Yeah.
what I just said? Thank you.
Absolutely. Yeah. Giving large lump sums after you've lost capacity is not really an option. And I agree that you need to be really careful about not giving away your assets that you might need because the last, I think it's 10 years of life or so, the cost of living just goes through the roof. So you want to make sure that you've got enough left to take care of yourself. So talking about enduring powers of attorney, um, so basically, this is the document where you name an attorney who's going to manage your assets in the event that you either lose capacity or just need extra help. So sometimes we put in an extra clause that says you can bring the power of attorney into effect before you've actually lost capacity, because sometimes elderly people just don't want to have to go to the bank and whatnot anymore, even though, they haven't lost their marbles, they just need help. So it's a really helpful tool, and it isn't just for incapacity, but it's very commonly associated with incapacity. Now you have to be careful to make sure that your power of attorney is an enduring power of attorney instead of just a regular power of attorney, because it's only the enduring power of attorney that will remain in effect after you've lost capacity. So when you need someone to make all of those financial decisions on your behalf after you've lost capacity, if you only have a regular power of attorney document, it won't do what you need it to do. So for the enduring power of attorney, it will cover everything to do with your finances, like your banking, property, any investments, dealing with your taxes, dealing with any businesses, anything like that. And if you don't have one, a lot of people assume that their spouse will just be able to manage everything for them, but that is not true. And I recently had a really tragic situation where a woman called me from the hospital. Her husband was in a coma, and she said, I need a power of attorney. And I said, well, like, he's not conscious. He doesn't have capacity to grant a power of attorney anymore. So at that point, you have to bring an application to the court for trusteeship, and that costs thousands and thousands of dollars and can take months, and is a really stressful process. Instead of spending that time and energy caring for the person you love, you're then stuck in a court process trying to get authority to act as a trustee. So a lot of people don't think about the importance of incapacity planning and having a power of attorney in place, but it is, I would think, maybe even more important than your will, because you're still alive at that point and you very much care who's managing your money. So I think that's a really important document to have for sure.
And we have a sister document that's relatively new. Sorry, Justin, just flip it over here. These are the personal directives. And when I say relatively new, I mean people are more aware and they do these more now. And Christian, I want just you to talk about this document because some people who listen, I know there are many of you who have wills that are 30 and 40 years old where you probably didn't put in a personal directive. So can you
Yes.
talk about what this is and what the goal of it is?
Totally. Yeah. So the personal directive it is basically the sister document to the enduring power of attorney, but this document is slightly different in that it's where you name someone to make all of your personal decisions on your behalf in the event that you lose capacity. So where do you live? Who do you hang out with? What kind of medical treatment do you get? When to pull the plug? All that kind of stuff. So you very much care who's making those decisions for you. And it might not be the same person who you want making your financial decisions. Like you might have a son who's a doctor who would be great for making the personal decisions, but your daughter's an accountant and she'd be really good with managing the finances. So you really want to look at the attributes of a good agent would be someone who has like good levels of empathy and they can understand what you want and how you're feeling, even if you can't communicate for yourself. But also willingness and ability to act. Age is important for this one because often, spouses are aging at the same time. And well, every spouse is aging at the same time. But you really want someone who is going to still have the capacity to make those decisions if you're, approaching 100. Um, so that, yeah, the roles are different for the agent under the personal directive and the attorney under the power of attorney. It might not be the same person, but it is important to name someone, because if you don't have a personal directive, just like with if you don't have an attorney, you're going to have to bring an application, but this time an application for guardianship. And that can take a really long time. All the same issues. And often with healthcare related issues, decisions are needed to be made like pretty quickly. So you don't want your agent to be waiting, or if you have no agent, you don't want your family member or friends to be waiting months and months for somebody to be named to make those personal decisions on your behalf, because that's a long time to be suffering in a situation that you never would have wanted to find yourself in the first place.
And I'm going to sort of chime in here as well. We always talk about the will as being the primary document because that's where the assets are, and these are the supplementary documents. But as you all probably know, I have two children, and they're adult men. They're both over 18. I want to call them not adult men, but adult children, but that's just in my own mind. Anyhow, the risk for them, having their mother and father having enduring power of attorney and a personal directive is more important, because if they get themselves injured and landed in a hospital because they were doing something stupid, which we know is quite possible, and I show up there, I have no rights. I'm not their mother anymore. I'm somebody who's I've got somebody who's over 18, and I'm an adult and I'm not listed anywhere. So for anybody who has adult children, where they're not, where they haven't done wills, you still need these documents, or you could be unintentionally, or, frozen out. And I gotta tell you, when I made my boys do their wills, it was tough because I said, you have to write a will. Why, Mom? I have no money. So I had to go through this whole scenario with them. I said, well, we have no money now. Maybe sometime in the next decade, you'll have $10. But anyhow,
Even if you
these,
have no
these
money,
documents are important.
yeah, it still helps your family to figure out what the next steps are, what your wishes were. A lot of people with young children have no money because children are just money suckers. And for them it's important to be able to name their guardians or the temporary guardians in their personal directive. There's so many areas that need covering above and beyond just the money aspect of it that these documents touch on.
So that's great. Sorry, next slide here, Dustin. Okay, so this is our last slide, isn't it? Sorry, I think we're getting closer to the end here. But so practical tips for estate planning. Here's a practical tip that I'm going to give you. And Christianne's going to tell me it. And I'm going to say, use a professional. Don't write it yourself. So Christianne, when you see wills that have been written by yourself, either by a holographic will, which means you hand wrote it, or one of those online will kits, because you think everything's simple, what happens when someone presents you one of these wills? What are some of the risks?
Yeah, so I think the biggest risk I see with these types of wills is that people, they don't know what they don't know. And so they think that things are simple and that you can just write it out and yeah, that looks fine. But they don't understand that, beneficiary designations can mean that certain assets pass outside of the will. They don't know that if you give like a certain like registered investments to your kids, that the tax bill for those investments can still land on the estate. So, giving one asset to one kid and a different asset to a different kid doesn't mean that they're going to be equal. A lot of times people want to split things up that way in terms of like, well, I know that this is worth roughly this much and that's worth roughly that much, but it doesn't take into account the fact that values fluctuate, or you might, draw down your entire RRSP by the time you've passed away. All sorts of things can go sideways with beneficiary designations, with joint assets, with situations where a trust should have been required, situations where there are any type of complex assets like businesses, situations where there's blended families and second marriages and children from first marriages or stepchildren. There are all kinds of laws that govern every single aspect. And unless you are a trained lawyer, you don't necessarily know what you don't know. So you can put it down on a piece of paper and say, oh, that was easy. But is that piece of paper actually going to do what you think it's going to do? in my experience, when I look at them, they don't. And it's those types of wills that most often end up in litigation. I'm not an estate litigator because it's a very, very aggressive form of law where, you know, the person who is making everyone behave themselves is now dead. So nobody's behaving themselves anymore. But most like estate litigators love holograph wills because they end up in litigation so often. And it's just a waste of your money. Like you didn't want your inheritance that you were trying to give to someone to be spent on legal fees. So yeah, I think that's the biggest danger with trying to do your own will.
Okay, that's great. And is there any and besides all of these legal reasons why you should contact you, technically, what are some of the technical mistakes that you see from these, like people not dating them or people not witness, like would be a technical mistake where they,
Yeah,
let's say it's somebody simple. They've got one RSP for 50 grand and it's going to their mother, and not an RSP, a non-registered account, and it's going to their mother. But so they just write out a will. What are some technical things that people don't do? I mean, not
yeah.
everything, but two or three things they miss when they use these programs.
Yeah, so if they don't have the correct number of witnesses or signatures, or they don't have it written as a, there are particular criteria set out in the legislation for what each type of will has to look like. So if it's a holograph will, it looks very different to if it's a formal will, and people might try to do a formal will but miss some of the formalities, like how many witnesses they need to have and the types of affidavits for execution they need to have. There are just a million ways that you can accidentally do the wrong thing.
Okay, that's thank you. That's kind of what I was looking for. Um, um, okay, I think that's as good. Just go on to the next slide here. What are we at here? Okay, so yes, we're just sort of wrapping this up. Um, I I think that we've gone through most of the questions that we had. David's, if your question didn't come through, oh, here's another one here. Um, this is a loaded question. So,
Ah,
uh, can I protect my estate from potential claims by ex-spouses or creditors?
good question. So, it depends, which I know people get very annoyed when lawyers say that. But
Well, this
with
is only
ex,
a one sentence question. This doesn't have a
yeah,
lot of details in it. So,
yeah,
we just need a general, you
yeah,
know,
yeah. Yeah, it very much depends on the fact scenario. If there is an ex-spouse who you have ongoing support obligations towards, then you probably still owe those after you die. Your estate probably owes them a lot of times. And I'm not a family lawyer, so there may be people even on the call who are family lawyers who know better about how this works. But I think a lot of times separation agreements and divorces stipulate that there has to be life insurance where the ex-spouse is the beneficiary, so that if something happens to you, then your estate is still able to fulfill your support obligations. Um, and in terms of protecting it from creditors, there is a whole load of, it's a very specific area of the law in terms of like bankruptcy and insolvent estates, and the set of criteria that you have to meet in order to successfully evade creditors. And I think one of the criteria is literally that you can't be trying to evade creditors. So that's a whole other kettle of fish if you're dealing with any type of creditors like that.
Okay. How about this question? And this is a question where one of the things I suggest to clients is get your will out, read your will. If it makes sense, put it back. If you get it out and you read it, it doesn't sound right, rewrite it. But can a will age out? Like, can you have somebody who's 95 who wrote their will, you know, 40 years prior
Yeah.
and
So
and thinks that the will's valid, but it's actually not valid? And what would cause that to happen?
So the will can still be valid. I have a will that I put in for probate last week. That's a 50-year-old will. So it can still be valid. I think the biggest issue is potential changes in the law that you're not aware of that impact how the will operates. So a big one, for example, recently was it was decided in a court decision that you might not necessarily have to be living together to be considered common law for estate law purposes.
What?
So yeah, and it was wild. All of us were kind of like, what? Like people, purposely living their lives separate and apart, not living in the same house, keeping their finances separate, doing everything they could to make sure that they were not common law. But the court still said, you spent every weekend at each other's houses, you were together for 30 years, you held yourselves out. Like there was all this criteria that the court went through, and basically determined that that couple was common law without them actually living together. So that might be
Wow.
challenged. That might change because I think everybody was like, this is bonkers. But yeah, so you just don't know when and how things are changing in the law unless it's literally your job to keep on top of that. So that I would see as being the biggest risk with letting your will sit without making changes.
And here's another one that believe it or not happens more than you think. But what about people who have multiple wills? So they have multiple jurisdictions. So they have, property maybe in BC and property in Ontario, and then they're actually French and they're a beautiful vineyard in France. And then, when they were working overseas, they picked up
Yeah.
some stuff in Australia and they've got, citizenship over there. Or when you've got international situations, what about China, right? China is another one.
Yeah.
Like
Yeah.
how do you manage international situations where you got assets in different locations and you have potentially different citizenships and residencies? What prevails, or do you have to have multiple wills? What happens roughly, generally, in 2 minutes or less? Oh,
Yeah, it varies a lot by jurisdiction, and I usually always recommend that if my clients have property in another jurisdiction, that they reach out to an estate lawyer in that jurisdiction. I have the TEP designation from the Society of Trust and Estate Practitioners, so I have access to a database of all of the lawyers who have that training around the world. So I usually am able to locate someone who can assist us and make sure that the two estate plans are aligned because the laws in the other jurisdiction could be completely different. There might be forced heirship, there might be all kinds of stuff. So it varies hugely depending on the jurisdiction. Some recognize Canadian wills, some don't. So yeah, it's all over the place.
okay, so definitely, if whoever asks that question, you need to call Christiane. You can't do that with a $30 will kit. So, anyhow, I think that this pretty well wraps us up for today. I think we've gotten through all the questions. And again, if anybody needs to talk to you, they can get your number from me, which or and we'll be happy to make that introduction. And other than that, Christian, if there's anything else you wanted to say before we wrap this up, I'm leaving it to you.
No, thanks very much for having me, Jennifer. Thanks everyone for coming. I am with Underwood Gilholme. If anyone wants to Google me, and it's Christianne Murphy. Um, yeah, so hopefully it was informative and you all are going to not be part of the 50% who don't have your estate plans in order.
Okay. Thank you, everyone. And I hope you all have a great afternoon.